We will discuss the construction of our plan. Can we allow the parties to come on record?
Mr. Nyamodi, the reason why we are mentioning these matters is to find out if any of them would be right for consolidation with the matter which is here, so that we don't duplicate.
Thank you.
My Lord, perhaps as you consider that, let me put it on record that if you are considering whether they are right for consolidation, the consolidation should not then slow down the hearing of the application that you have already identified as that. If they are to come on board, they come on board and proceed from where we are.
Let us be on board first. We respond to you appropriately. Allow us, even the LSK former president, to be on record.
My lady and my lords, I just have a passionate plea to make. There are not many pleas. The first plea is this: we consider utilizing the ceremonial court on the ground floor because it is spacious and sufficient for all of us. That's number one. Number two, my request is this: the court has all the petitions. Why can't the assistants to the court enumerate the parties there in the quorum in the manner we used to do in the Court of Appeal before? So that when we appear here, whatever time we indicate, we'll just fill our respective names and the court will be able to deal with the matter without the need of this back and forth. Number three, my lords and my lady, I think the court needs to just be a little bit proactive. When you retreat, you may make two decisions. One, either to determine the interlocutory applications, in which case you can frame issues for the parties to submit them. Or two, if you're minded to hear the petitions themselves, then still frame the issues and forward it to us so that we're able to make progress. That way we make good use of the judicial time that is very limited in this particular. I beseech you more.
Thank you, Mr. Harvey. Well taken.
As former chairman of the Council of Science, let me second the first issue and plead that if only for the purposes of everybody getting sufficient oxygen, because we are too crowded, and the people want to listen, and the media and the members of the public, if it is possible, let us use the ceremonial hall.
Council, Senior Council, we will use the ceremonial hall as from tomorrow.
Thank you.
And
I wish to say that perhaps when giving directions, then and if parties, files are going to be consolidated, then it will be proper each person is served with the application so that we are able to respond, even if we are given a day to respond, so that when we begin to submit, we are able to submit according to the law, not as per the bar and whatever issues are being raised. Thank you.
thank you.
My Lord, I was going to beseech the court, if we are to make progress, I'll beseech the court to invoke its powers under Section 55, Article 159. We go on and on. There is no shortage of legal provisions enabling this court to rein in on the lawyers. Because if you don't do that, my Lord, on a matter like this, where you're 20 lawyers, 50 lawyers on the other side, we will be coming to you. We'll be doing legal gymnastics, legal ping pong, what I call legal sophistry on other occasions. And meanwhile, we'll be lamenting as we are now lamenting to you. So there are applications, both from this side and this side, certified agent. Meanwhile, we are spending a lot of time, each of us from whatever side, starting to raise this or other housekeeping issue. I beseech you, my Lord, in a matter like this, the court must be very firm. It must run the council. The court itself must have very clear direction. Which is the application that will be had, in what sequence, what are the time allocations, how the parties share those times.
We have agreed on that, and what we ask is let us mention these matters so that we know how they relate to the other matters which are before the court. So we have mentioned 570. We have mentioned, we have 570. We have mentioned 570. There's
570.
This 550. 550. We have mentioned E570. E550, Speaker of the National Assembly versus Rigathi Gachsgua.
This file is already consolidated under the cohort of 550.
$550.
No, I'm sorry, my lord, that was not.
Yes. 550. Who's in 550? Who is in 550?
My lord, mine is 572.
I'm asking 550.
Yes, my lord, in 550. Milimani, my lord, we appear for the first respondent.
I guess you can tell us who is the application.
The petitioner, my lord, is the former deputy president, my lord, represented by my very senior.
My lord, I appear for the deputy president, not former. He remains in office on the basis of the conservatory orders, and each bench has confirmed weighty issues, which is why we are here. Let's not join the rush.
For the first petition.
For the first petition. I thank you.
My lord, if it pleases you, Nyamodi and Gumbo for the second respondent. And our learned colleague, Mr. Muruga.
That matter, my name is Kele. I appear together with Ms. Angie and my senior professor, Brenda, for the third and fourth respondent.
Yes.
That's all.
Who else is in this matter? So, for the petitioner, Mr. What are the issues in this matter? Are they relevant to the consolidated petitions?
There are so many files here.
This is
The same team of lawyers,
yes.
including myself that I gave when we came for the ruling, is appearing for the deputy president.
What I'm asking is it going to be consolidated or is it standalone?
One of the ones that we are consolidating.
My lord, sorry if I appear repetition.
Yes, speak, please.
For you to be able to progress, I beseech you adjourn this matter tomorrow. Go and make directions. You're either hearing the petitions or the applications. Come here so that we have a perspective before we progress. Otherwise, we will not move.
We are alive of that fact, Mr. Habi, that you know,
It's my advice.
you know, it is the councils who will be saying that their right to be heard, even on petition, even if the slightest issue has not been granted. Therefore, let us agree on the way forward. If you make a proposal can come from you your side, how you want to deal with all these petitions. Is it possible that you want to ignore all applications and proceed the petitions? You can make a submission which this court can consider.
My Lord, if I may, just to guide the court, and on this account, I will do it as senior counsel. My Lord, there are urgent applications before you. The applicants or the petitioners had their bite yesterday on a plenary objection that the court has ruled on this afternoon. My Lord, we have an urgent application that was filed before you, dated 18th October 2024, for discharge of the conservatory orders. Whatever decision this court makes can be either way. We lead to directions on the hearing of all the consolidated petitions. Some of the petitions, my Lord, deal with issues or causes of action that arose before, my Lord, the impeachment. The proper position of the law is that the party who is the petitioner is the former deputy president. That's the position of Article 145(7). Allow us, my lords, to urge our application for the setting aside of conservatory orders. I think, my lord, that's the only way we can move, because they have had their bite, let us have our bite as well. We will only take 30 minutes, we request.
I'm not disagreeing with you, Professor Jenda. What I'm saying is that let's mention these files. We are on the third one, and if you have not been interrupting, perhaps we'll be through with them. 550, I've recorded the forum, and what I asked, is this file related to the files before the court? For the purposes of consolidation, or it can stand alone?
Can we deal with that? We're not more. We only do the
Because there is a
we only deal with the forum. Consolidation has implications. I need to consult my team. I need to consult the client. Let's take the forum. Let's deal with the consolidation too.
So we mention it tomorrow.
Yes.
Next. Five 41, Dr. Clarence Eboso. Dr. Clarence Eboso.
My lords and my ladies, my name is Milimani. I am acting in person, and I am the second petitioner in the matter. The first petitioner, Dr. Clarence Eboso, is online, my lord. My lady,
May it please the court. My name is Dr. Clarence Eboso. I'm the first petitioner in E541. The petitioner is between Dr. Clarence Eboso, Ms. Wanjiru Mwangi, versus the Speaker of the National Assembly, the Attorney General, and with the Law Society of Kenya as an interested party. The petition relates to the process of impeachment, particularly in the National Assembly, and seeks orders to quash the proceedings in the National Assembly. The petition has an application which was certified urgent and which sought an injunction against the entire proceedings of impeachment. The court which certified it urgent directed that the application would be heard by the bench that would be constituted. Several of the prayers that were made in the application have since been overtaken by events. However, the substance of the application sought to conserve the issues as they were, and therefore the conservatory orders that were issued by the court in last week on Friday protected some of the prayers that we had made in the application. Yesterday, I pointed out to the court that proceeding with the discussions on the conservatory orders would have prejudiced us because then we would have lost out without participating.
Yeah.
Our prayer would be
No.
Exactly the application. We are taking so long.
Just tell us, Mr. Clarence, whether this petition, you want it to stand alone or whether you want it to be consolidated with the petitions for the court.
that's where I was going to go.
Just go there, please.
I will be seeking that the petition be consolidated with the petitions relating to both the impeachment process and the filling of the vacancy that arises from impeachment. The reason being, upon filling of any vacancy.
Okay, we have heard you. You are agreeable to this petition being consolidated with the petitions which are in file number 565 of 2024.
My Lord, may I just conclude? My Lord, may I just conclude that I would be willing to compromise our application, provided that we can be allowed to participate in the applications for conservatory orders that are before the court in the interest and in time.
With your permission, my Lord, I appear for the first respondent.
Yes.
And my Lord, I noted that we didn't come with our file.
Is this petition post-Senate proceedings?
No, my Lord. It has not mentioned before. It was filed, my Lord.
Before.
Before. And it has not touched on issues, my Lord, that happened at the Senate. Ordinarily, my Lord, will be opposed.
So we mentioned this matter.
Tomorrow, my Lord.
We mentioned this matter on 29th when the petition number 522 will be mentioned.
Most of likely.
Tomorrow or the 29th?
My Lord,
Yes?
I'm not sure if the court got the last statement I made. It would be greatly prejudicial to us if the discussions relating to the conservatory orders continue without our participation, because we are essentially raising the same issue in our application.
My Lord, I agree. We filed our application on the 8th of October 2024 before the National Assembly and even made its impeachment to Rigathi Gachsgua. We are active persons, we are laymen, my Lord, and we are also protected by the same laws, Article 27, Article 47, 48, and 49, and 50, my Lord, for the right to fair hearing. So we do ask the court does mention our matter tomorrow so that we can articulate the points that we need to.
My Lord, I appreciate the fact that the petitioners are appearing in person. My Lord, once the court has made an order, Well, the only remedy available to the parties is either to appeal, my lord.
We have not made any order. You know, we talk before we get matters.
Sorry, my lord,
So we mention this matter tomorrow.
be available.
572. 572.
Yes. My Lord, the presiding judge, my Lord, my lady, what business in the matter. My name is Wamboi, Shadrach Wamboi. I have the honor and privilege of introducing counsels for the petitioner. I appear alongside my learned senior, Mr. Dunstan Amari.
I'm present.
Mr. Samson Nyaberi, my senior.
I'm present.
My learned colleague, Mr. Nicholas Karanja.
I'm present.
And my learned colleague, Miss Melissa Omeda. We all appear for the petition applicant. Thank you.
My Lord, in that matter, I am Shadrach Moses, the Solicitor General, appearing for the Attorney General, together with Professor Gitu Mugai, Senior Counsel, Emmanuel Peter, Deputy Chief State Counsel, Charles Mutinda, Deputy Chief State Counsel. Multiply now.
My Lord, if it may please in the matter, Milimo, my Lord, I appear alongside Ole Kuyoni for the first respondent.
May I please you, my lord? For the second respondent, my name is Bumbo. I appear together with my learned senior colleague, Mr. Paul Nemodi, and Mr. Honorable Tonga Brugara.
If you may please, my lord, my lady, that matter, my name is Edwin Bukele. My lord, I appear together with the senior professor of gender, my lord, Senator Hilary Sigay, and Miss Matthew Kanji, for the third respondent, my lord, in respect of this matter. For the third respondent, Speaker of the Senate.
The Deputy President is the interested party, and I appear with my colleagues, Mr. Ngoya, Mr. Macharia, Jomo, Devwa, Kipa, Wandati, Victor Swanya, Faith Muge, Faith Waino, and Mr. Muge, for the interested party, that is the Deputy President.
Thank you, Lord. My Lord, just to respond to the question whether this petition should be consolidated with the others, the questions that have been posed in the instant petition question the constitutionality of the impeachment process at the Senate that led to the removal by way of impeachment of the Deputy President. Secondly, my Lord, it also questions the constitutionality of the appointment of Professor Kithure Kindiki as the Deputy President designate in that office. And for that reason, my Lord, the view that we take with humility is that the petition is ripe for consolidation. And my Lord, just for the avoidance of any doubt, and my lady, we have an application filed and dated the 18th day of October 2024 that sought an order of conservatory order to stop the implementation of the decision made by the Honorable Speaker of the Senate, Honorable Amason King. So, my Lord, when we canvass or we are to canvass the applications as to whether the current conservatory order should be disturbed or not, we want to actively, when we seek humility, to participate in those proceedings. Thank you.
Mr. The parties, are you opposing the possible consolidation?
Yes, my Lord, we are vehemently opposed, my Lord, to the joinder or intended consolidation of this petition, but also that we don't take time before you this evening. We would prefer, my Lord, that this matter also takes the cue of being mentioned tomorrow with the others, my Lord, where we will substantively, my Lord, be presenting, my Lord, before you reasons why this matter should not be consolidated with the one that is before you today. And my Lord, so that we save time, I speak for all the respondents.
Mention tomorrow.
Sorry, my Lord.
Mention tomorrow.
We mention tomorrow.
My Lord, if you permit me. My Lord, there is a mischief that we need to cure or to safeguard ourselves against. My Lord, there is an attempt to have a litigation by way of installment in this matter. So much so that, my Lord, if you look or you find time to look at the petition and the application, you will see that the issues that are raised by my seniors and counsels for the petitioner are synonymous, they are the same.
Since it is not consented to, why don't we listen to it tomorrow?
Most obliged, my Lord, because the question of consolidation is a question of law, and it's purely on a principle question. And my Lord, we will be ready to argue the question of consolidation as and when we are invited. Thank you. Yes, please. My Lord, my Lord and my lady. Yes, I am guided by my senior counsel, Paul Mwito. The question of consolidation is one that even the bench, as it is currently constituted, can actually look at the matters and on its own motion, suo moto, give directions or orders, whether it is deserving to be heard alongside the other matters, or we just need to take a cue behind other petitioners.
The court has spoken. We mention it tomorrow. Thank you.
Let's consider that tomorrow.
Most of that. Thank you.
This file has a mention date for 29th of October, but because issues are arising, we wanted to mention it again today if there is any issue arising out of it.
in terms of appearances, and in order to save the court's time, the same counsel that I enumerated are appearing for the petition, the deputy president, in this matter.
Yes, my lord, for the respondents, a quorum, similar, my lord, so that we save on time. My lord, we would be willing, my lord, to present before court two options. Either, my lord, we retain the mentioned date that has been given, or, my lord, you mention the matter tomorrow, so that if there is anybody who want to address you, we address you tomorrow, my lord.
We don't want to talk tomorrow with so many matters. If there's no need, we can retain the 29th.
We can retain the 29th, my lord.
We can mention it tomorrow. Let's mention the matter tomorrow. So we are clear with the mentions. We can go back to petition number 565.
No, you have not mentioned my matter.
Which one?
509. 509.
It was consolidated with
Sorry, I'm sorry, I never had you call it out. I'm sorry, Mr. Kid was keeping me busy giving me. My lord, in that respect, we have an application. The lordship, I hope it's on record. We could also mention and get directions tomorrow on my application for the recusal of the bench dated the 22nd. I would be most obliged, lordship.
We are mentioning the matter tomorrow.
Most obliged.
So then we are back to the petition number 565.
We wish to confirm that on the part of the Attorney General of the Republic, we are ready to argue our application certified urgent by this court or by the court referring the matter to this court.
Well, I believe this is the matter that we have earlier indicated, that after all these matters have been consolidated, directions have been given in these matters, specific directions need to be given for purposes of that matter. And for purposes of enabling those specific directions to be given, I want to point out three things. Number one is that we will need directions on when the first application that was to be done after the validity application is determined, when we are going to be had. That is issue number one. Issue number two, my lord, that is important, is the fact that now that today the Honorable, the Chief Justice has caused all of us to come on the basis of these other matters, the point needs to be noted that for purposes of the basis for all these matters that empanelment was done, the reason was that there were applications for conservatory orders. Those applications for conservatory orders were first certified as urgent and would be the first business of this court appearing there, assuming there is no other preliminary issue like recusal or otherwise. Thirdly, my lord, is this, that for purposes of those applications where conservatory orders were made,
The conservatory orders may have been made in 2 or 3 files, but they conserve the status quo that is cross-cutting in all the petitions that are before you. Apart from the fact that in that particular petition, the one that has conservatory orders, when this court, because all those applications were done on Saturday, the parties, starting at least with those that I represent, because of the nature of the proceedings that were there yesterday, we have not completed doing the responses to the applications by the Attorney General to lift conservatory orders. We could not be able to do the authorities for reasons that were indicated. And more importantly, my learned colleague, Mrs. Kemodo, whose file has been consolidated, did indicate she has not even been served, and in that matter, she needs to respond and be heard. Therefore, my Lord, in considering these issues that is itching the group that wants lifting of the orders, I would like the court to give directions bearing in mind that the stakes of the parties, all the people who have filed petitions, is to ensure you are not faced with a fait accompli, where you are told, we have already sworn Kindiki and you can go to hell. We do not want to be faced with a fait accompli situations. My Lord, it would be absolutely important that the subject matter is preserved, if not for any other day, until all the parties are before the court. Your Lordship.
Yeah, Your Lordship. There is
You can see that
We will proceed in these matters as follows. By tomorrow, we will issue comprehensive directions on various issues. But importantly, Parties are already aware that there are two cohorts of matters. The first cohort involves the petitions which were filed challenging the happenings before the National Assembly. Those petitions will proceed as cohort 1. They are the subsequent petitions which were filed challenging what transpired in the Senate. That is cohort 2. By tomorrow, we will deal with the issue of consolidation. We are aware of the powers this court has on the issue of consolidation, just like how we exercised the powers yesterday. We may decide to either hear or give directions on the consolidation. However, we are in agreement that the next application in line can only be one, and it is the application for recusal of this bench. And that is the application which, after we do everything, tomorrow at 2:30 is up for hearing. If you intend to participate in that application, in the second cohort, that application is coming up for hearing tomorrow at 2:30. In the morning, we will deal with the issue of consolidation. That one we will give direction on that. So that is the way forward. Prepare to hear the application for recusal of the bench tomorrow at 2 p.m. In the morning, we will deal with the procedural issues of consolidation and any other issue which may arise in cohort 1 and cohort 2. Thank you.
Those are very clear directions by what you mentioned. And we entirely agree that you assist in the orderly progression of the hearing of this case. Thank you.
Just for the record, my lord, we assume it is all the 3 applications for recusal.
There will be no other application for recusal. We will hear what is on record, and it will be a ruling will be delivered. There will be no other application for recusal. And we think that that should come first, because if you don't want a bench, there's no reason why we should do any other
Fair
thing.
enough, my lord, I was only pointing there are 2 or 3 of them.
Yes.
And the only clarity I'm asking is whether all applications for recusal will be handled together.
Yes, together, all will be handled together.
Yes.
Your Lordship, finally, as you categorize these pleadings in cohort 1 and cohort 2, I kindly allow me to remind the court that the last time we were before you on the 16th, the court gave or granted leave for parties to amend their petitions. So there could be petitions that have now crossed over to cohort 2, pursuant the amendments bring in light the transpired. Perhaps the pleadings will be as with most.
Mr. Negwa, those are some of the preliminary issues which we'll deal with in the morning. But principally prepare to argue your application for recusal at 2:30.
I am ready even now.
Before we break, with your very kind permission and indulgence, I would like to put the deponents of the affidavits that have made very, very grave allegations about judges of this court to be present tomorrow at 2:30, because we reserve the right to cross-examine those deponents and to move the court as appropriate after that.
Well, perhaps if I may request that the court supplies us with a typed copy of the ruling that you have delivered today. We know you are working under very tight timelines, but we would very much appreciate a typed copy of the ruling that you have delivered today. We believe it may be useful in the tasks at hand tomorrow.
Thank you, Your Lordship. These are ruling that you delivered on 16th of October in the consolidated petition 522.
I believe you can get a copy of that ruling as well. The ruling should be available.
So, yes, finally, my judges, I think there is a law about service, that there are some parties who are present and have not been served, and we've been hearing this from the inception. I think tomorrow we settle the issue of service. We also settle the issue of filing of any affidavit or responses that ought to be done, so that after 2:30, we know how best we're going to proceed without people intervening with, I have not had sufficient time to this or that.
And I think before my presiding judge addresses, I just want to remind the parties that we are using technology to move. To me, the issue of service should not be a big thing, because if you are marked into a matter, automatically you get everything, unless you are not in the system. And if you are not in the system, get in touch with the deputy registrar. As simple as that. So that we avoid these issues of I was not served, I was served, I was not served. Let us make use of the technology at hand. Thank you.
May I suggest that, Lord, we are appearing tomorrow in the ceremonial hall at 11. I was going to plead that any other issues being raised from the bar be raised tomorrow at 11. No.
My Lord, as the chair in charge of all the people who are retiring, as they can vote at this particular moment, all the people who are
Just to avoid any doubt, the application for requisition will be heard at 2:30. Whether you have responded to it or not, we will hear it. We will not allow any adjournment on it.
At what time tomorrow morning, sir? Because some of us did get things.
Tomorrow morning at 9.
At 9, yes.
Yes.
And we're told 11. It's at 10 o'clock.
We're most obliged, my Lord, we can see you
For clarification, physical or you can do
I think that concludes our sitting today. That concludes our sitting today. See you tomorrow.
Deputy CJ, several additional issues have been raised. The bench found it necessary to address these issues so as to ensure both the completeness of the record and finality in the issues raised. During the submissions, an issue was raised concerning the